Today we're discussing Florida gun law. Specifically, we're talking about the Florida state statutes that allows or doesn't allow the concealed carry of firearms on or about your person. If that's something you're interested in, stick around. That's up next. Years ago, while flying with a firearm in my suitcase, I was detained in New York City because of that firearm. I don't want you to have to go through that same circumstance, so I want to explain to you Florida's gun laws, specifically with regards to concealed carry. Ask your questions down below. Maybe I'll make another video, maybe I'll answer the question, or maybe somebody in the group will answer the question. If you already know me and you want to skip forward to the content, you can do that right now. If we haven't met yet, my name is Jeff Lauder. I'm a Florida-based attorney, and I use my unique experience as a former law enforcement officer and military veteran to help people navigate some of their most complicated problems. Today, we're talking about concealed carry of weapons and firearms in Florida and what the law says. Anytime we're having a legal discussion regarding guns and firearms in Florida, you got to go to Chapter 790 of the Florida State Statutes. It has just about everything you need. And if you take a look, you'll see the first thing on the list is definitions. The very second thing is unlicensed carry of concealed weapons or concealed firearms. That's where we're going to be diving into, but I want to keep scrolling down here and look at a couple other things. Possession of a firearm and ownership responsibilities, sale and delivery of firearms, improper exhibition of dangerous weapons or firearms, use of firearms while under the influence of alcohol, armor-piercing bullets. A lot of good stuff there. So before we dive deeper into the actual concealed carry statute, let's take a look at the definition statute so we can identify any key words that have significant legal meaning more so than what we're familiar with in a day-to-day use. Let's do that now. Let's look at the definition of firearm. Any weapon which is designed to or can be converted to expel a projectile by an action of explosive, including the frame or receiver of any such weapon, any firearm muffler, silencer, any destructive device, or any machine gun. Let's take a look at the weapons statute, figure out how that applies. Subsection 13 has the definition of weapon, means any dirk, knife, metallic knuckles, slungshot, billy, tear gas gun, chemical weapon or device, or other deadly weapon except a firearm or common pocket knife, plastic knife, or blunt-bladed table knife. Wow, that's a lot of stuff. So a weapon can be just about anything except for the things listed in here, is what I make that out to be. We now have a pretty good idea, or at least a working definition, to talk about a distinction between weapon and firearm. Let's jump into 790.01. Except is provided in subsection 3. Okay, so we're starting off with some exceptions right away. We'll discuss all the exceptions later on in the video. We'll get to those in a minute, but let's put those aside. Let's get into the law. Except is provided in subsection 3, a person who does not hold a license. So if you don't hold a concealed carry permit, this applies to you. So a person who's not licensed and who carries a concealed weapon, or electric weapon or device on or about his person commits a misdemeanor of the first degree. Okay. Misdemeanor, we're talking about two separate degrees of crimes here. We have felonies, which are the higher level, more serious ones, and then we have misdemeanors, which are the least or less serious of the two. But misdemeanors also have two different categories as well, M1 and M2. Misdemeanor of the first degree, misdemeanor of the second degree. Misdemeanor of the first degree is punishable by 1 year in jail and a $1,000 fine. That's the maximum. I'm not saying you're going to get that, but that's the maximum. So carry a concealed weapon, maximum punishment, 1 year, $1,000 fine. Let's go on further in the statute to subsection 2. Same language, except is provided in subsection 3. We'll discuss the exceptions. A person who's not licensed, we talked about that. If you don't have a concealed carry permit, they're talking to you. And who carries a concealed firearm on or about his person commits a felony of the third degree. Now, a felony of the third degree is the more serious of the two charges, misdemeanor felony. We just talked about that a minute ago. And a felony of the third degree is the least serious on the rung of felonies. That's punishable with a maximum of 5 years in prison and a $5,000 fine. So subsection 1 of the statute addresses weapons. We talked about that definition. Subsection 2 addresses firearms. But if you remember back as we were skimming through those definitions, there was a definition specifically for concealed weapon, and there was a definition specifically for concealed firearms. So let's take a look at those. Concealed firearm means any firearm defined in subsection 6, we already talked about that, which is carried on or about a person in such a manner as to conceal the firearm from the ordinary sight of another person. So do you have a firearm on your person that's hidden from ordinary sight of another? If so, that's a concealed firearm. If you don't have a license for that, then you're guilty of a felony of the 3rd degree, unless one of the exceptions apply. So let's move on to the exceptions. This particular statute has 2 ingrained exceptions with regards to the carrying of concealed firearms. There's also exceptions that apply outside of this statute, but the default position is if these 2 exceptions don't apply, you are guilty unless you can point to another exception. So that burden is going to be on you to say, hey, I qualify under this particular exception. You're going to find the statute that does that. The 2 exceptions included in the statute, one has to do with non-lethal, dart firing stun guns, or electric devices, or pepper spray. So less lethal options. Those are authorized to carry concealed for the purpose of self-defense. The other exception has to do with evacuation during states of emergency within particular time frames. If you want more particulars about the details of these exceptions, I've included those in a handout and some notes I made in a PDF document. I'll put a link to that down below. I next want to talk about what the officers are going to do and what they're charged with doing when they find someone in violation of this law. To do that, we're going to look to Florida State Statute 790.02. And you'll see the title speaks volumes about what the officer's actions are supposed to be. Officers to arrest without warrant and upon probable cause. That's what the title of the statute is. The carrying of a concealed weapon is declared a breach of peace, and any officer is authorized to make arrests under the laws of this state, may make arrests without warrant of persons violating the provisions of 790.01 when said officer has reasonable grounds or probable cause to believe that the offense of carrying a concealed weapon is being committed. Florida is known as a pro-gun state, but make no mistake about it, the carrying of a concealed firearm or weapon is a serious offense and declared a breach of peace. You got to make sure you have your I's dotted and your T's crossed when you're carrying a weapon in Florida. To do that, I want to tell you about another exception to the statute, what I think you're going to like. Florida has a statute that makes it lawful to carry a firearm inside your vehicle in a concealed manner. That's going to be Florida Statute 790.25. It's under lawful ownership, possession, and use of firearms and or weapons. And if you go down to the very last subsection of that statute, which is subsection 5, it says this: possession and private conveyance. Private meaning personally owned. Conveyance is just a fancy word for car. Notwithstanding subsection 2, so no matter what it says in there, it doesn't matter. It is lawful and is not a violation of 790.01. That's the statute we were discussing earlier, the unlawful carry, for a person 18 years of age or older to possess a concealed firearm or other weapon for self-defense or other lawful purpose within the interior of a private conveyance without a license, if the firearm or other weapon is securely encased or is not otherwise readily accessible for immediate use. Nothing herein contains prohibits the carrying of a legal firearm other than a handgun anywhere in the private conveyance when such firearm is being carried for lawful use. So you're going to have to dissect that on your own. I think I'll do another video about it in the future. Ask your questions down below. I'll put some more explanation in that resource if you want to download it. Appreciate your time. Hit it hard. Thanks for watching.